Hello everyone and welcome to the Data Protection series. My name is Lazarus Kalu. I am a data protection and technology lawyer in Nigeria, and I regularly provide actionable insights on how to comply with the Nigerian data protection laws. If you have not subscribed to this channel, kindly do so, like and turn on your notifications so you don't miss any of our videos. In today's video, we'll be talking about an interesting subject for businesses. You know that in some businesses, even in your business, sometimes you send emails, SMS to your customers and to your potential customers, telling them to come and buy or subscribe to your products and services. Now, for you to do this thing, you use their email addresses, use their phone numbers, so you have a means of communicating with them and use that means. Remember, in our first video, we talked about the meaning of data protection, and we said that personal data means any information that can be used to identify any person. So phone numbers, email addresses that are used to advertise to your customers and potential customers are personal data. And using them to advertise to them, you need to do that in compliance with the Nigerian data protection laws, because sending them SMS, sending them emails qualify as a processing activity within the meaning and scope of the Nigerian data protection laws. So today we'll be talking about direct marketing, which is a communication that you make as a business to your customers, telling them to subscribe or purchase your products or services. And how can you do this thing in line with the requirements of the law? Because if you do not comply with the requirements of the law, you will likely be fined or penalized for such violation. Now, under the Nigerian data protection laws, especially the Nigerian Data Protection Act, for you to use someone's email or someone's phone number to send to that person information regarding the goods you are selling or the services you are offering, there are certain obligations you need to comply with. One is you must have a legal basis. Two, you have to comply with the transparency principle. And three, you have to respect the customer's rights. Now, let me explain these things. And before I even explain, let me just do a recap of what I've said so far. So if you are involved in direct marketing, which is a communication of marketing materials or advertising materials to your customers or your prospective customers, and for you to do this, you usually use their emails, phone numbers, which qualify as personal data. So for you to do this marketing and direct marketing, you need to comply with the Nigerian data protection laws. And to comply, you need to have a legal basis, you have to be transparent in your practices, and you have to respect these customers' rights. Now let me explain this thing one after the other. In one of our previous videos, we talked about the legal basis for processing personal data. If you have not watched that episode or video, please kindly go and watch it. But that video dealt with the basis for processing personal data. Number one is consent. Number two, contracts. Number three, legitimate interest. Number four, public interest. Number five, vital interest. So for the purposes of direct marketing, there are only two of them that are relevant: consent and legitimate interest. Now, if you are sending marketing materials or advertising materials to your customers or to your prospective customers, you must show that you have collected and these persons have consented to receiving this type of information or marketing materials from you. And how do you show consent? You know that consent shows that it must be freely given, meaning that there is no compulsion on the part of the customers to receive from you. So they must freely give you their consent. They must be properly informed, and this has to do with you telling them why they are consenting. So they must understand that they are giving you consent for the purpose of receiving information regarding your product and services. And 2, they must indicate by an affirmative action, which means that they must give you that consent either by writing it for you or by ticking a box or something like that. There is no room for implied consent. So you can't say that they have given you consent because they have given you their information. No. If you are relying on consent, you must ensure that that consent is valid, which means that you must be fully given, you must be informed, and the person must have acted by a positive act to give you that consent. So if you are not relying on consent, how can you do it? Consent is usually difficult to get because you can only get consent from your existing customers. For your prospective customers, there is no how you can get consent from them. The only way you can send to them or even to your existing customers is to show that in the past they have purchased something from you, and based on that you have collected their information and you are sending them information, advertising materials regarding your product and services for goods that are similar to the goods they bought in the past. So for existing customers, you can ask them to buy your products and services when they have not given consent. But for you to do that, you must prove and you must establish that in the past they must have purchased something from you. So that is it about legal basis. So if these two circumstances do not apply, you cannot lawfully send information regarding your products and services to these persons. Now, if you have established that you have a legal basis, which is either consent or sending it to existing customers, you must do another thing, which is transparency. In one of our previous videos, we spoke about the principles of data protection in Nigeria. And one of the principles is that you must process people's personal data in a transparent manner. And what does this mean? This means that you must inform them before you collect the information that you will send them advertising materials. And you will tell them how long you want to be sending it to them, how you will be sending it to them. So, in essence, these persons, both your customers, your prospective customers, should be aware from onset that they will be receiving information regarding your products and services from you. So one way you can do this is by having a good privacy notice. We'll make a video subsequently on the contents of a privacy notice. But for our purpose today, in your privacy notice, you should be able to tell your customers and your prospective customers that the information, their phone number, their email address that you have collected from them, that you will use it to send information regarding your products and services, that you use their email, their phone number to ask them to buy more products and subscribe to some of your services. So you have to be transparent from the beginning. So as you are collecting the information from them, you will tell them what you are going to use it for, which is to send information regarding your products and services. So the third point is that you have to respect your customers and prospective customers' rights. So under the Nigeria Data Protection Act, one of the rights of a data subject, which in this case is your customer, is that they have a right to object to whatever you are doing with their information. So if you have sent marketing materials, advertising materials about your goods and services to your customers or your prospective customers, they have a right to request that you stop sending it to them in the future. And once they do that, you have to respect that right. Because if you do not respect that right, they have a right to sue you in court. They have a right to file a complaint against you to the Nigerian Data Protection Commission. So, of course, you don't want to be involved in any of these things. So, you have to respect the customers or prospective customers' rights. And another thing the law requires that you do is this. If you send out information regarding your products or services to your customers, in each of the information you send out, you must give them an option to unsubscribe. So they must have the option to say I want to opt out from receiving information from you in the future. So if you do not give them that option, you will be in violation of the law. This brings us to the end of this video. I hope you have obtained good information from it on how you can send out marketing materials to your clients and customers and prospective customers. If you have not subscribed to this channel, kindly do so and turn on your notification videos, as I regularly provide actionable insights on how you comply with data protection laws in Nigeria. Thank you.